Master Treasurer, Master Reader, Masters, ladies and gentlemen, non-binary and gender fluid colleagues. Good evening, my name is Rahana Popal and I am acting as chair for tonight's Inner Temple Education Department's Existing Practitioners Programme talk. Tonight's talk is Good Practice when Working with Trans People in the Legal System and the Courts, presented tonight by our wonderful speaker, Reagan Persaud. Before introducing tonight's speaker, I will cover a few housekeeping matters. For those joining us online, you should have been automatically muted on joining, but please ensure that you are on mute and remain so for the entirety of the session. For those in person in the room, we are not expecting any fire drills tonight. If you do hear the fire alarm go off, please evacuate and find your nearest exit. We will be recording this session, though there will be a focus on the speaker and the presentation, but we'll try to capture as much of the atmosphere in here and take as many questions as we can. Chatham House rule will apply this evening. Moving on to our excellent speaker, Reagan Persaud's Twitter profile describes her as a lawyer, fitness instructor, and amateur chef. David Locke Casey's profile her as the only BAME transgender barrister who recently shared her struggles and hopes for the future, for his Breaking Glass Ceiling podcast. Reagan was called to the bar by the Inner Temple in 2013. She practices in children law from Spire Barristers Chambers in Leeds. Her website profile refers to her as extensive knowledge and experience of issues relating to gender identity and the difficulties that can be faced with these matters when these matters arise. In particular, she understands trans issues and the difficulties that trans clients can face during proceedings. Legal 500 profile has her as a force to be reckoned with, extremely capable and diligent. She is a fierce, confident, and a fearless advocate in court. Tonight's talk will cover from a specialist in the field of representing trans people in court, the relevant terminology relating to trans people and the risk to trans people if good practice is not adhered to. The Inn recognises that there are alternative viewpoints. Reagan's talk will be for around an hour, followed by Q&A session. For those here in the lecture theatre, please raise your hand and wait for the microphone to be handed to you before asking your question. For those online, please do feel free to submit your question via the Q&A or the chat function. Following tonight's lecture, for those attending in person, there will be a networking opportunity outside. Without any further delay, I'll hand over to our excellent speaker, Reagan Persaud. Thank you.
Good evening, everyone, and thank you for coming to this seminar tonight. I was asked to deliver this seminar, and it's something that I deliver quite regularly now. So the content, perhaps you'll see a lot of it repeated because you've possibly attended this before. But I always want to open this by explaining why I've chosen to create and deliver this seminar. I am the only one of my kind in England and Wales, and probably further than that. When I came to the bar, there was no one like me there. There wasn't a trans person of colour at the bar, and sadly, we remain in a situation where I'm the only known trans person of colour at the bar. I always think it's therefore even more important that we get this out there. It would have been very easy for me a few years ago, when everything kicked off recently about trans people in the media, to go underground, if I can put it like that. And I won't stand here and say I didn't think about that at times. But I think, having reflected on it, it's important that we do these sessions. It's important that we educate people, because the reality is, most of us, and in particular my fellow colleagues at the bar, most of us just want to get it right. And we're a little bit worried about the terminology, and we're a little bit worried about the sensitivities. So the seminar is designed to assist you all in understanding that. And it is with that spirit that I ask you to take it. The only other caveat I have to add is Dr. Jackson is sitting here, who is far more of a specialist than me on this subject. So without further ado, let me embarrass myself in front of Dr. Jackson, right? So what we will cover today then, what we'll cover is this: an overview of relevant terminology relating to trans people. We're going to look at the history of trans rights, particularly in this country, to see where we've come from and where we're at now. We're then going to look at relevant guidance that the judges have to follow from the Equal Treatment Bench Book, and we'll consider how, as practitioners, we should be following this and what we should take from this as well. Alongside those considerations, I will give you wider considerations that you need to be aware of, and even things like the competing interests that can come into play, because we know that things are never absolute in the way that we would hope that they would be. So let's turn to it then. I think before I turn to the terminology, one thing I want to say is this. We know trans people exist. We know that people like me are around. But the reality of the situation is very few people know how far back it goes. And I'm going to say to you that it goes back as far as we can remember. There are cultures in southern Mexico that have always identified a third gender. They did it before Spain colonized them. We know in India there has been a third gender since they could remember. And that's always been in their depictions and their paintings and their written work. So it's important that we recognize that this isn't something new. This isn't something that's just arisen in the last few years. Trans people are here, we've always been here, and will probably always be here. With that in mind, let's turn to the language around trans people and what you need to be aware of. I think the first thing I'll start with is the very, very basics. There is a distinction, which a lot of people don't know about, between sex and gender. Now, sex as a concept tends to refer to someone's biological or physiological characteristics. So for me, I was born male and my sex will be male, and that is a fact. So if someone was to talk to me, that is what sex refers to, that's my sex. On the other side of that coin, there is gender, and gender is in essence a social construct. When people talk about gender, what they are referring to is how you identify, how you present yourself, and who you, in your mind, are. Now, I always explain this by trying to talk a little bit about myself, so I'm going to be a little bit personal and possibly a little bit vulnerable about this. I can remember back to when I was... What am I doing wrong, David? Oh, there is. I thought I could see that, but no one else. Got it? There we go. Yes, well done. So I can remember from when I was very little. I can remember when I was 4. And I was raised in a very Christian household, a very Catholic household. My mother told me, if you get on your knees and you pray to Jesus, you'll get whatever you want. So every night from the age of 4, I would get on my knees and pray to be a girl. And I always say God works in mysterious ways, because here I am, right? Maybe not the way I intended it to happen, but I know that from a very young age, that was my identity. And I remember growing up that unless I was interacting with someone in a social setting, I would walk around as female. I don't think anyone walks around going, I'm a man, or I'm a woman, but you have that subconscious presence, identity, sense of identity of who you are. And for me, I was always female. The only time that would be challenged is if I interacted with someone and they would say, cheers, mate, thanks, buddy. And then I would get this shock back to reality that actually, no, that's not who I am, that actually I'm a boy. And that was my childhood. That was all of my childhood. And there were constant interactions of that nature. As a result, I developed a male persona. And what I mean by that is I developed the Reagan who would interact with the world as a boy, as male. And I always thought that's probably who I am, if I'm honest. I thought all boys were like that. I thought every boy was a girl in their head, but they just presented as a boy. If you don't know differently as a child, that's genuinely what you think, right? So it took me many, many years to unpick, hold on a minute, that's not how it works, right? And along that journey, I had this front. I had the male front, but when I didn't have to interact with the world in a social setting, I was a girl in my head. The way I would think, the things I would do, the way I would view myself and think about myself, it was always female. Then when I got into my early 20s, I realized that there was such a thing as trans. And I realized that actually that's what I was. I spent many years being 2 people. And I don't think anyone ever understands how hard that is, to have a female person in your head and a male, at the time what I thought, person in my head, and trying to jump between the presentation of one and trying to navigate the language, because believe it or not, there is a generally socially constructed way that girls speak and boys speak. And whilst there's some overlap, as a general rule, you grow up knowing that you're allowed to use certain language as a boy, you're allowed to use different language as a girl. It was difficult navigating the two. It distracted me a lot in terms of what I could achieve. And then when I finally discovered what trans was, when I finally discovered who I was, I reached the point where I thought, no, you could persevere with this. You can bury the girl and you can just be the boy, and you can survive with that, because quite frankly, it would have been a lot easier. It would have been a lot easier culturally, socially, legally. And I was at a crossroad because I had pupillage and I had the prospect that I thought that I would lose my pupillage if I decided to transition. And I always remember the day I was holding the steering wheel driving, calling my supervisor, yes, I know I can be arrested for this, I don't care, on speed dial, hands-free, and I said to her, I'm trans, I'm going to transition. I very much expected her to say, you couldn't have this pupillage, you're going to have to rethink that. Thankfully, my set didn't, and they were very welcoming, and they were very encouraging, and I was able to do my pupillage. The reason I tell you this story is because I had to overcome all of that. And I had to overcome and risk losing my career, losing my family, losing everything to be myself. Once I'd figured out who I was, there was no going back. Once I knew that all boys weren't girls in their heads, I couldn't continue to live that life. After I transitioned, overnight, and in an instant, the boy died. I don't have two people in my head anymore. That persona is completely gone. So when people speak to me about it and they say, well, how do you know? It's because I don't have two people in my head anymore. One died instantly. And to me, that was the one that never existed. To me, that was the one that was socially constructed because I had to present as male. The minute I chose to present as female, I am one person in my head. And let me tell you the things you can achieve when you don't have two people in your head. Let me tell you how far I've come since then. Reason I tell you that story is this. One has to recognize when we look at these issues, gender is a social construct. I will stand here and tell you from my own experiences, there is such a thing as having to present a certain way. And for most people, the two align. For most people, your gender and your sex go hand in hand. For some of us, it doesn't. And when it doesn't, it is agony. Surviving it, living through it is agony. And making the choice to be your real self can involve risking losing everything. Let's talk about trans then. Trans is an umbrella term. It can mean, well, it can cover a lot of people. There are those who, like myself, whose gender identity do not correspond to the gender assigned at birth. So I was assigned male at birth, and they identify with the opposite gender. Or there are those who, we say quite broadly, aren't entirely consistent with the binary of male and female. They can go between the two, they can identify something in the middle, they can choose either to disregard both of them altogether. So you then have non-binary people, agender, gender fluid, and genderqueer. One thing I will say is avoid the term transsexual. Sadly, in much of our legislation, we still say it, but there is a real struggle around that term. The trans community, and in particular transgender women, are very heavily fetishized. And again, I can tell you about my own personal experience of men coming up to me on the trains and asking me if I'll have sex with them for money by virtue of being trans. Those are not normal things that normal people go through. Those are things that as a trans woman are unique to my struggle. Calling us transsexuals implies a sexual nature. And it is for those reasons that I always say to people, avoid that terminology. It is considered archaic, outdated, and I think it carries connotations that are quite harmful to the community. Let us not forget, this isn't just my struggle. There are lots of examples where that happens all the time. Who remembers Bridget Jones, where Hugh Grant slept with the Thai boy and discovered he had a penis, and that was a running joke in Bridget Jones? Who remembered Sex and the City, when Samantha described her neighbor and her village trendy by day and tranny by night because they were a sex worker? So actually in public, in the media, we see it all the time, that trans people are normalized to be sexualized objects. And it is something we can avoid either by using the term trans, which is broader, or transgender, say in my case. I'm quite comfortable with that. Let's turn to the rest of it. So trans man, trans woman, someone who has transitioned from male to female or female to male. Transition as a concept, it doesn't have to be hormone therapy. A lot of people think this means a medical transition. A transition can be a physical one, it can be a mental one, it can be and it is a psychological one. But you can transition without actually ever being on hormones. So for instance, to get through to the gender identity service in the NHS, you have to have, and start hormones, you have to have lived as the opposite gender for a year before they'll allow you to access treatment. I was lucky in that because I was in this career, I could access funding and went private. But there are a lot of people you will see who you will think, you don't really pull that off. You look like a man in a wig. And I say that because I ask you this. I ask you to have sympathy with those people. It is not as easy as you would think to access hormone therapy or treatment. And one has to live that way. One has to live in a body without any treatment and be ridiculed by people in society for some time before the gender clinic will actually allow you to access hormone therapy. If you're the kind of person who doesn't have private means and the funding to secure that, that has to be your reality. That has to be your lived experience before you can become who you are. Cisgender women, cisgender men, cis woman, cis man, in essence, those are people who are not trans. There are groups of people who will find such terminology insensitive, who will find it offensive. I take the view that actually it is about respecting everyone's choices. So if someone doesn't like to be called cis, don't call them cis, just call them a woman. I know, and I am very aware of all of the views that there can be about trans people and about how we identify. And my view through all of this is simply this, is we all have to tolerate each other. We all have to live together. And so if finding out people's preferred ways to be referred to will resolve issues for both sides of that camp, that is where we should be. That is what we should be trying to do. Your assigned gender is the gender you were giving at birth. So for me, male. Your acquired gender is the one you then move to acquire if you transition in any form. For me, that would be woman, that would be female. And as I say, transitioning can be social, medical, physical, mental. Passing then. Passing is a terminology, it's quite an old terminology, but none of this language is ever sophisticated, really. It's just how well you pass in society. I am very aware that having undergone hormone therapy now for about 12 years, I pass very well. And so I have something called passing privilege. And we all know, we all hear it, check your privilege. I'll be the first one to tell people that. I have to check my privilege sometimes. I have to recognize that I can walk around and the world will not bat an eyelid at me. I can go to court and my clients don't know about me. But there are those who cannot. And there are those who will find the journey so much harder because going to the supermarket can be an opportunity for ridicule. I am grateful that I don't have that, but I think we all have to be alive to the fact that there are many who do have to undergo that struggle. And we have to think about when we will work with these people in the court setting, how will they present? Will they be shy? Will they be nervous? Will they be worried about ridicule in a court environment? When one considers the way they have had to endure hardships as a result of how they might present, an understanding of that will assist you as practitioners to know how to approach them, to recognize those signs, to be aware that they may need more assurance as clients or as witnesses than perhaps other people who have not had to live through that type of experience. Misgendering is calling a person by the wrong gender, or for instance, pronouns, or even names, calling them the wrong names. And likewise, we move on to dead naming. It used to be called slave naming. That's what I grew up with, but it's more commonly called dead naming. I think I'm too old now, and the kids have moved on in the language. So dead naming is referring to someone by the name that they originally had. For me, I always think, like I say, slave naming for me is the name that tethered them, tethered them to birth was that name. It's your slave name. And it's the same concept with dead naming. They've become someone new, they've reborn as themselves, and you are killing them by referring them to the wrong name. So I raise that because one of the obvious things you will face as practitioners in the court arena is, what if someone hasn't legally changed their name then? What do? Do you respect that name? How do you deal with that? Well, there is guidance on this, and my view and the guidance is this. No one has to be called by the name recorded on their birth certificate. How many times do we go for Kathy instead of Catherine? How many times do we go for Rick instead of Richard? And actually, if someone has a preferred way that they would like to be referred to, deal with it as a preliminary issue in the hearing. Set out at the very first hearing, the second hearing, how is it you would prefer to be referred to? Record it on the order, that is the way the person prefers to be referred to, and then the rest of the documents can show respect for that person by referring to them by that name. This is not trans-specific. As much as people would like to make it at times trans-specific, there are lots of people who prefer to be called a shortened version of their name or a different name because they were called it in childhood, or a middle name. There is a simple solution to this, which makes sure that that person is respected and everyone else is aware of what they should be doing and how they could properly address that person. So that is the easiest way to deal with it, which nicely brings me into a case that I did want to discuss with you. It's the D'Souza and Primar case, because we have to be aware of what can happen if, for instance, someone doesn't get it right, if they decide to deliberately flout these sort of guidance, and how that can end up happening. D'Souza was a case whereby a trans woman worked at Primark in 2016. She told them she was transgender, and her birth name was, of course, a male name, and it was on her passport. But she had made it clear that she wished to be referred to by her female name. Now, pausing there to assist everyone, some people do change their names, some people don't. My mother named me Reagan, and she had no idea that this was more of a girl's name than a boy's name. So I never had this problem. I could just continue using the name. But if my name was Dave, it might be a bit harder for me to decide to transition and to be who I am with such a name. The problem is there are other considerations in play. What about the cultural issues? There are many cultures where being LGBT, and T is the focus of tonight, might result in ostracization, it might result in violence, it can result in hate crimes and honor killings. A person may choose to not change their name legally for many reasons. So I have a friend, for instance, she's called Adele. I don't know her legal name, but I know, because I've had this discussion with Adele, she has not changed her legal name, because whenever she goes back to India to see her family, she has to enter that country as her birth name. She has to present in that way. And as distressing as it is for her, that is the only way she can have a relationship with her family. Which then brings nicely into the point I'm making of, we can respect people's identities even if they don't change their names legally, because we, of course, will understand that there may be many reasons why people don't do so. Some of those being deeply personal, some of those being the fear of the consequences and the loss that they can suffer if they do go through in that process. So D'Souza didn't change her name legally. Well, HR then mistakenly changed her name on the company system and referred to her as Mr. as well. The result of that is that, of course, everyone then found out and knew that she was trans, and her supervisor began calling her by her male name, by her legal name, and laughed whenever the supervisor was corrected. She then alleged that staff started spraying men's perfume over her until she was coughing. They said she had a man's voice. They made jokes about her sexuality, and they even told her that she was evil and she was a joke. She made a complaint, and Primark said, "You're overreacting, you're being dramatic." And eventually, of course, she left. She took it to a tribunal for constructive dismissal, and she was found to have been discriminated against. And the tribunal, I'm moving ahead, and actually I have a whole slide on this, and you're missing the benefit of my beautiful slide, aren't you? The tribunal decided to award her some $47,000 in compensation. This is from 2017, so that's 6 years ago. This is what trans people faced 6 years ago. It's not that long ago. We're not talking about the 50s and the 40s. We're talking about 2017. And what the tribunal said is that there can be certain things that are implemented to assist companies, to assist businesses to be supportive and respectful of trans people. Adopt a written policy on how to deal with new and existing staff who are transgender who wish to undergo gender reassignment. Include a reference to the existence of a policy. Amend the materials used for equality training. Ensure that transgender discrimination and harassment is referred to in all its equality and harassment policies, and add content into training materials on how to handle grievances that might arise. Pausing there, this is a big company. It's Primark, isn't it? And I think we'll all tell a lie if someone doesn't know something from Primark in this room. Am I right about that? At least I can see from the ladies, you're all going, yes, Reagan, we definitely do. How does this apply to what you might come across as practitioners? Well, most of you are either in an employed setting or in a self-employed setting. Would these rules apply? Is there good practice for us to take from this case? Well, the Bar Council tells us, and I'm on the Bar Council, so I know this, I'm telling the truth, that we must show respect for trans and non-binary people. And of course, this is the guidance that they hold on their website. The Bar Council supports trans, non-binary and gender fluid barristers. We support those who aspire to the bar to be who are trans, non-binary or gender fluid. We support them to be protected. We recognise the Equality Act protections they have, and the Bar Code of Conduct protects them. And we encourage all chambers to, look at it there, ensure that they have a policy regarding equality and diversity, policies regarding bullying and harassment and victimisation, and training on such issues. This is from the Bar Council website. If you are in a set or an employed setting, D'Souza is relevant. D'Souza and the spirit of it is still relevant because we see it in what the Bar Council encourages us to do. For those of you who don't know, the Bar Council has trans policies that you can adopt and implement in your place of work. They have transitioning at work policies that, again, you can adopt and implement in your place of work. And I would encourage anyone who wishes to be on the right side of how we treat people and to be as inclusive as we possibly can to look at those documents, to consider them within your own establishment, not least because I am partly responsible for writing them. So let's move on then from D'Souza. Let's talk about the concept of trans more generally. Now, I've already addressed with you that trans people go way back in history. But actually, today, let's talk about the modern day. How many trans people are there around? Well, it says that trans people make up 1 in every 2 to 5,000 people in the country. The census in 2021 noted that there was around 0.5% of the population that fell into the non-binary trans category. So we're talking about less than 1% of the population. Bear that in mind when I tell you that the Daily Mail in 2021 ran 300 articles on trans people. That is almost an article a day on 0.5% of the population. So we have to remember that when we are talking about trans people, we are talking about a very small group of people. We are talking about one of the smallest, if not the smallest minority group in this country. There is evidence that being trans, experiencing what's classed as dysphoria, comes from genetics, but the reality is it's a massive debate, and I will say to you, it doesn't matter where it comes from. As a trans woman, it is real. The pain is real. And what can flow from it, sadly, is a lot of prejudice. A lot of trans people start to feel a difference from about 5. Well, I remember mine was 4. And puberty can be incredibly distressing for trans people. Again, as practitioners, be alive to this, because if you work in crime or family or immigration, you will have minors, won't you, who might be trans, who may have an identity that is different from the norm, different from the binary. Be conscious that for these people, there are real issues that start to show up in the puberty stage. Be conscious that you need to be alive to. If, for instance, your client is presenting as very down, very sad, very depressed, these are the kind of things that might be playing on your clients' minds. Remember that, therefore, as practitioners, we have to and we should show empathy. It is a battle in the mind, and we know as mental health is invisible, isn't it? When we believe that people are suffering with mental health issues, it is a belief. We don't see it. It's not a visible scar, but it is there and it is real. If you notice in any of your clients, in any of the witnesses you might work with, that actually they may need some support, encourage them to access it. Remember that for minors, trans children, the Canadian Medical Association Journal identified in 2022 that trans teens are 7.6 times more likely to attempt suicide. So there are very real risks here to this vulnerable group of people, children in particular, that you will be working with. But also, when you will have to factor that in, bearing in mind the other things we've discussed. So, cultural background. If they are the kind of person who comes from a certain background where their identity may not be accepted, that may be a relevant consideration. Their support network and how accepting their support network might be around who they are. The schools and whether in fact they are experiencing bullying, whether that might be linked to their gender identity. I certainly experienced a lot of bullying. Everyone else around in school knew I was trans before I did, which is always the way it is with children, isn't it? But it is relevant. And the availability of medical treatment, because the reality is there is very little out there. So you as practitioners have a lot to juggle, a lot to think about when you will work with these vulnerable people. The best way you can do it is at least being able to recognize that these issues come into play. So let's then turn to practical information, is what I call it, the kind of things that you need to know a little bit more about. We've dealt with names briefly, but I'll say this, names carry a lot of significance for all of us. It can symbolize who we are because we've had these names since we were children, but for a lot of trans people, Dave, who had to change Dave's name, it can represent a part of who you are reborn to be, who you have chosen to be, in the sense of expressing your identity. And it can sometimes represent the journey that you've come on. So destiny, for instance, might be a name. I've seen persevere as a name. I've seen bravery as a name. It doesn't always have to fit into the binary. We have to try and think beyond male and female. Some people might choose a name that is more akin to how they feel. And names, for that reason, are incredibly significant. There is nothing quite like the dagger that comes from someone either misgendering you by getting your pronoun wrong or by calling you the wrong name. Remember that the people in front of you have to go endure that. A lot of us have to endure that all of the time. So I wasn't as fortunate to pass as well as I do now. Back in the day, in my early stages, before hormones took effect and before my hair grew out, I was misgendered a lot. And it takes so much strength just to walk out the door every morning, to face that world, only then to be kicked 10 times before I get to Tesco with he. And it's a pretty big kick. And it is that emotional kick that we all know. Emotional damage is not visible. It's not something people can see, but it is cumulative. It is insidious, and it can eat away at you. It can make you worry about walking out the door, about going down the street, about enjoying a meal out in public. Names and pronouns are very important for these people, for my people, because it signifies who we are, and it is part of being accepted in society for who we are after we've struggled probably our whole lives with figuring this out. It comes into play every day, so many times a day. It carries so much significance. And remember, as I say, it's not actually a formal requirement to change any of it. That applies for pronouns as well. There's no legal way to change your pronoun necessarily. Pronouns are a social construct. So if someone asks you to be referred to by a certain pronoun, there is nothing that they have to legally do to then have the right to say you must refer to me as the other pronoun. They don't have to justify that. The only time that names can become really relevant is when you, as I say, interact with the state. So passports, birth certificates, employment. And as I say, even in those settings, there are rules that we could make to accommodate people's preferred ways of being addressed and things that we should do to try to assist them. You can change your name in two ways. You can do it by statutory declaration, or you can do it by deed poll. This is if you choose to legally do it. Both are valid, but as I say, neither is a necessity to have recognition of your chosen identity. If you do it by statutory declaration, it's just a form that you sign and you get someone else to sign and witness. If you choose to do it by deed poll, it can be enrolled. And if it's enrolled, it'll be in the London Gazette. The problem with that is it's then a public record. And so people can very easily find it. And Dave becoming Samantha will be far easier to identify as trans if this is a public record. So Master McLeod had to deal with this issue in WFC and D minors because we had some examination boards saying that for trans children, you must change your name by deed poll for it to be recognised. Master McLeod identified the very issue I'm talking about, which is you will in essence out those children if you do this by deed poll, and gave a judgment that said if the reason for changing the name was one of gender reassignment, what we will do is we'll mark the file as private, and the only thing in the Gazette will be the surname. And anyone who wants to inspect it further will have to apply to have permission to do so. So that was a safeguard put in place to assist and protect trans children, trans minors. Of course, as adults and trans adults you will work with, that is still a relevant consideration. The reason I flag this is because you may well have trans clients who want to know how to do this. You may well have trans clients who want to know, how do I do this? What's the most efficient way of doing this? And if I want to protect myself, want to move on, have a fresh start, how can I achieve that? There are your answers to those questions, whether they be for adults or for children. That is what the law says. But as I say, pronouns, they're a social norm, no legal requirement of change, and some people might even choose to have gender fluid and neutral pronouns, such as MX, that they use. Just on a side note, and this is a personal bit of advice, one of the things that I have found in my own practice, working with many trans clients, trans people can be very shy about volunteering that they're trans. Anyone that's been on Twitter, and I refuse to call it X, anyone that's been on Twitter, here is me telling you to respect people's names and then saying I'm not calling it X, right? Anyone that's been on Twitter will know there's a war. There's a real war, and it's really painful to watch people invalidate your existence. Take that from me on Twitter. When you will then work with people who might be trans, they will have the battle I have, which is, if I reveal this to someone, how will they react to it? Will I get the response I hope for, or will it damage my relationship entirely with this person? And you'd be surprised the number of people who change in the minute you tell them. So to assist people, I include this at the bottom of my email signature. My pronouns are she, her. If replying or emailing and you wish to specify yours to assist me, please feel free to do so. It is a very simple way to introducing to anyone you may work with who might be trans, that you are open to that discussion. You are open to knowing that they may have a preferred way to be referred to, and you are willing to respect that. I accept entirely it's not something that's mandatory. But if anyone understands the importance of this when you are in a world of being persecuted, then I would encourage you to include it. Let people know you were willing to listen. Feel free to have open conversations about pronouns. I think this is relevant across the fence because, as I say, there are lots of people on either side of these arguments. But the one thing I find is that everyone will be willing to talk about how they wish to be referred to. For most people, you don't have to do this. Most people, as I say, their gender will match their sex. It will be obvious how they wish to be referred to. But if you come across someone that you think, I have a question mark about how I should refer to this person, I think 99% of trans people will say, if you say to them, what are your pronouns? How should I refer to you? They will gladly give you that information because we're desperate just to get for people to get it right. So bear that in mind, that I would encourage you that actually if you are in any doubt, there is a respectful way to open that conversation, to have that conversation, and then to respect the answer given thereafter. Let's turn then to the issues of transparency and risks to trans individuals. We've covered some of this already. As I said, be alive to the risks. Note that privacy can be key, particularly around cultural issues, particularly around the situation where they might be ostracized. Note, sadly, as lawyers, if you work in family and crime and immigration, much further afield, you'll know that sometimes we're not just lawyers, we're counselors, we're therapists. I've been so many things to so many clients. I've been so many shoulders for relationship breakdowns. When I was younger, I wanted to be an agony aunt and give people advice and tell them their business. I feel like I do that a lot in family law. I don't know about the rest of you, but I seem to always be telling my clients how to live their lives and what to do. And I'm very conscious that you, as practitioners, will come across that. You will have to work in that, which is why on these slides, I want you to understand the kind of issues you will come across and what you can do about them. Remember, the risks of being outed or targeted, particularly from those from ethnic minority backgrounds who are trans, can be a lot higher. And when you will come across things like, should we be in a public court hearing? Should we publish a judgment on these particular issues? Be alive to the need for privacy. Consult your clients who may be trans to find out how would that impact on you if this gets out. Jigsaw identification is far more common than you think when it comes to trans people, particularly because there are intersectionality issues. So you can have a person from India who is trans, who will have 3 children, two who are mixed race, one who isn't. The 2 of them will be twins, one of them will have a particular learning disability, and all of a sudden that person's identified. And so you have to be very conscious as practitioners that these particular details can end up outing people. Jigsaw identification is real, particularly for minority groups. Remember the quote that I will give you, the lost ones, a quote from the Human Rights Campaign Foundation Vice President Jay Brown. Fatal violence against transgender and gender non-conforming people is a tragic result of a society that devalues our lives, with Black and brown trans people facing significantly higher rates of harassment, bias, and physical violence. An ABC report on the 16th of November 2022 said that 32 transgender people were killed in 2022 in America. So this is even now, this is last year, this is what we're living through. And you might say, as I tend to do, well, those are the Americans, they've got guns in schools, they're all sorts of crazy. But it's real, and it's at home more than you would realize. This is the United Kingdom statistics from the government website. Hate crimes recorded against transgender people. Watch the rise from 2017-18 to 21-22. It's up 56%. That's the reality we're dealing with now. Crimes against trans people are at a much higher rate. It's probably the highest rate it's ever been. And why? Why is that? Why is that happening? Well, this is what the website says. This is what the police think the problem is. Transgender identity hate crimes rose by 56% over the same period, the largest percentage annual increase in these offences since the series began. Transgender issues have been heavily discussed in social media over the last year, which may have led to an increase in related crime. Now, I've spoken to you briefly about the Daily Mail and the number of articles they run. Who remembers the case of Lucy Meadows? No one. Some people? No? So I'll remind you. In 2013, Lucy Meadows was a school teacher. She decided to transition. She informed the school. Did I say 2019? I meant 2013. She informed the school who were very supportive, who encouraged her to transition, and who said, that will be okay, you can return to work once you transition. A letter then went out to all of the parents, and the Daily Mail got involved. Lucy Meadows sadly committed suicide in March 2013. Why, you might ask? Well, for instance, Richard Littlejohn ran an article in the Daily Mail which repeatedly misgendered her and criticised her for returning to work after her transition. There was a series of media outlash at the fact that this woman would return to work in a school setting after she transitioned. And whilst she complained, and she did, she complained about harassment from the media, ultimately matters continued and she committed suicide. The coroner at the time criticised the Daily Mail and used words to describe them as having ridiculed and humiliated her, and it was character assassination of a school teacher. When I tell you that these are the realities of the situation, one has to be conscious of it. Social media, the media themselves, we have to be alive and we will see these things, that this is the impact of the actions. I'll go back again, up 56% in terms of hate crimes. And that's the UK. Put aside the US for a minute. And this is last year. So who are the most vulnerable in these communities? Well, as I say, intersectionality issues can compound the difficulties. Those from racial minority groups, those who have social mobility issues might find themselves struggling, and those with learning difficulties or disabilities may find that it's even harder for them. These are ultimately the most vulnerable people in our society. And throw it into the pot trans issues, and all of a sudden they are very vulnerable indeed. Be alive to other forms of discrimination that might exist. So it's very easy for us to go, if someone calls me a tranny, they're probably being discriminatory. Don't ever call someone a tranny, by the way, don't ever do that. But we know unconscious bias is real. There are more subtle ways to jab at people. And I will ask you as practitioners to be alive to that when you will work in the courts, when you will work with clients. Everyone has at some point, including myself, misgendered someone. It happens innocently, but watch out for the people who are repeat offenders. Watch out for the people who may be doing it in a way to intimidate, to undermine, to harass people. And those are the real culprits that the system should be looking out for, and you as practitioners should be aware of. As I say, other people do it, and they do it instantly, but you want to be aware of the ones that will do it in a way that will be unconscious bias. So, you're the therapist at court, you've got a trans client. What qualifications did we get at bar school on therapy? I don't know. But we seem to have everything right in that regard. And your client is in distress. Where can they access support then? Well, the first port of call is the GP, because they should be considering these issues and making appropriate referrals to the gender clinic. There is the gender clinic that they would ultimately end up at, who would give them proper support, but be alive to the fact that there are long waiting lists for this. When I first signed up to when I got seen by the gender clinic was 5 years. 5 years of 50 quid a month for my injection and hormone therapy. Thankfully, I can afford that. A lot of people can't. So just be alive to the fact that these things take time. You have to get there, though. You have to start the process. The GP is the first port of call. If your clients can afford it, if they have the option of private providers, I've listed a few there that they could get assistance from. There are charities such as Mermaids who try to assist as best they can. And of course, one thing I've written there in my typical family lawyer hat is if you have a child who happens to be trans and they happen to be in the care of the local authority has certain duties towards them. That may mean that you could push and pressure the local authority to make sure they access support as and when needed. So that's probably my worst slide, I hope, because you all look really sad, and I'm sorry to make you all really sad. But let's move on to the brief history then of trans rights and where we're at today. Sadly, I'm going to say that the picture doesn't get much more positive. The reality is in the 1950s, there were heavy prohibitions against anything homosexual in nature. Now, I use the term homosexual here very broad because in the 50s, there was no concept of L, G, B, and T. everyone just classed themselves as gay under a big umbrella because that's how it was viewed. You were all different. You were all part of the same problem, which is you weren't fitting into man or woman. You weren't fitting into what a man should be doing if you were sleeping with other men. You weren't fitting into what a man should be doing if you identified as a woman, and vice versa for women. So in the 50s, prohibition, everyone across the board. By the end of 1954, there were 1,069 gay men in prison in England and Wales, with an average age of 37, including some high-profile arrests, people who did good in this world. The scientist, mathematician, and wartime codebreaker Alan Turing was convicted in 52 of gross indecency. 67, so we move forward a little bit, and again, some people will remember this time, we had the Sexual Offences Act decriminalising homosexuality for men aged over 21, on the condition it was consensual in private and between two men who had attained the age of 21. The law didn't change in Scotland until 1980 and Northern Ireland until 82. The Wolfenden report around this time said homosexuality cannot legitimately be regarded as a disease because in many cases it is only the symptom and is compatible with full mental health in other respects. So there was progress starting to be seen, but it was slow. We all have heard of or remember Section 28 and all of the difficulties that that brought for the LGBT community. Local authorities shall not intentionally promote homosexuality or publish material with the intention of promoting homosexuality. Promote the teaching in any maintained school of the acceptability of homosexuality as a pretended family relationship. We're all playing pretend at this point, aren't we? 1988. I was born in 89, so it's not that long ago. Sadly, the courts weren't necessarily much better, and it has taken the court, as it often does, time to catch up, time to recognise other issues that can arise. So let's look at a family case, because I am a family practitioner, RED, an infant adoption parents' consent. This was a case where the couple had separated. And on the decree nisi, the mother put cruelty. That was the allegation that led to the divorce. Cruelty. But her main allegation was because he was homosexual. So cruelty because he's homosexual. That was enough to grant her a divorce. She then got a new partner. They decided to raise the child together, and she wanted her new partner to adopt the child. The father, the homosexual father, would have to consent to this. He objected. And so the real issue in the case was, could he, what they classed as reasonably withhold consent, or was it unreasonable? That was the idea behind the case. Bearing in mind what the argument was about him unreasonably withholding consent was this: A, that he'd failed to maintain a relationship with the child, but B, that the father was a practicing and admitted homosexual who associated with young men. By the way, young men, they were all of age. They were all legally of age. So that was the issue. And it went to trial. And there was a huge trial where this gentleman was asked about all of his sexual relations, where he was asked about who he slept with, where he met them, how old they were. And in the end, he admitted to having relationships with men. And ultimately, the adoption order was granted. On appeal, it didn't get much better. The danger is that, and this is from the appeal judgment, if he associates with his father, this is the child, he will learn about homosexuality in the most damaging way through the peculiarity of his father. It is inconceivable that he would not learn what his father is, not who his father is, what his father is. And he will go through the kind of things which may scar him for life. So that's where we were in 1977. And then a wave of changes happened, and thankfully, positive changes. 79, the Harry Benjamin International Gender Dysphoria Association was founded. They then tried to understand for the first time ever, really, trans issues and the concept of gender dysphoria. The World Health Organization declassified homosexuality as a mental illness in 92. By the way, the Spice Girls only came out in 95. So this is very recently. This is happening. If people need that to be in context, that's your context, yeah? Wannabe happened in 96. 4 years before that, homosexuality was a mental illness. Age of consent changed in 94, and in 2001 went down to 16. For the first time ever, same-sex couples could marry, and the first marriage took place in 2014. And when it comes to trans people, the European Court of Human Rights found that forced sterilization in order to have your legal gender recognized was a violation of human rights in 2017, so 6 years ago. And 4 years ago, who decided that transgender health issues were no longer a mental illness. So 4 years ago, mental illness, that's what I would have been classed as many other people. One has to recognize, and the reason I go through this is to help you to recognize that when trans people will talk about the struggle, when they will talk about persecution, this is 6 years ago, this is 4 years ago. This is not something we're talking about from the 20s, 1920s, or before that, or the 1800s. It is now. Thankfully, the court started to catch up as well. In a case of P&S, which was a Cornwall case, P had been dismissed from her workplace after informing her employer she was undergoing gender reassignment. She took them to a tribunal, and it was really one of the first pieces, if not the first piece of law, to prevent discrimination in employment and vocational education on the basis of being trans. To tolerate such discrimination would be tantamount as regards such a person to a failure to respect the dignity and freedom to which he or she is entitled and which the court has a duty to safeguard. So we start to see change. We start to see change in 96. We then moved on to the case of Goodwin and the United Kingdom in 2002. And we see here a landmark change for the trans community. Ms. Goodwin had faced sexual harassment at work. Her and I chose to remain anonymous, protested the lack of legal recognition for trans people, their gender and their post-operative sex, poor treatment with respect to employment, social security and pensions. And a decision was made that the United Kingdom law, well, English law, had violated the right of transgender people to a private life and the right to marry and start a family. It led to 2004, the Gender Recognition Act, which for the first time ever gave us proper legal recognition. Now, I will criticize the Gender Recognition Act for a lot of things. If nothing else, it uses the word transsexual. But it was the first piece of legislation that really recognized trans people, that recognized who we were and gave us proper rights, really, in the grand scheme of legislation. And then we had the Equality Act in 2010. 2010 is 13 years ago. Person who has the protected characteristic of gender reassignment, if the person is proposing to undergo, is undergoing, or has undergone a process for the purpose of reassigning the person's sex. So we got protection. We became a protected characteristic, which meant that for many reasons, we would now be safeguarded in a different way than the situation was before 2010. So where does that leave you, and what should you take from that? As I say, recognize that the hardships that trans people can face and the non-binary community in general can face are real. Recognize that the change is very recent. Before that, there was a lot of discrimination. And be aware that our practices must make sure that there is no discrimination. Respect costs nothing, and you're giving it to a group of people who even now continue to face a lot of discrimination. Recent Stonewall reports in 2018 and 2021 still talk about a third of trans people struggling to access healthcare, still talk about 50% of trans people struggling in employment and feeling discrimination, still talk about 40% of trans people being afraid to go down the street because of discrimination. We are not talking about things from the 1920s, we're talking about the situation now. And as a family practitioner, I've given you 3 cases there because I think that they're just more for interest, but I'll give you them anyway. Jay and Mina was from 2016. And I give you this case because people always want to know about trans children and where they fit into this. The mother had claimed that the child was gender variant and allowed the child to present as a girl. The court felt that in fact this was pressure from the mother and decided to change the situation and made a care order. It was ultimately found that the mother was pressuring the child at the age of 7. Contrast that with the case of Lancashire County Council, TP and others, where a 6-year-old was presenting as full-time female by the foster carers who had supported this. The court heard expert evidence and decided actually for that child, that was the right thing to do. That child knew its identity, she knew who she was, and ultimately that the foster carers were right to encourage that. And the court said, I observed during the course of the hearing that issues relating to gender identity and the medical understanding of such issues is complex and developing, and that inevitably there is some lag between those professionals at the cutting edge, such as the expert who gave evidence in this case, and others, which might have played some role in how these proceedings came about. And then finally, the case of Ries, one of the more recent cases, involved a 15-year-old trans boy him and his family decided to go abroad so that he could undergo a double mastectomy. Just so you know, the NHS doesn't allow surgery for children at this age. You have to be 18 and above before you can access surgery. So this boy wanted his mastectomy for the same reasons I've said. Puberty is hard. Decided to go abroad. His parents and him had made that decision together. Local authority brought the matter to court, tried to use the inherent jurisdiction to prevent that. The guardian was appointed, met with the parents, met with the child, felt that the child was legally competent. The parents had understood the issues and had made the right decision. The local authority, stubborn as they were, took it all the way to trial, and then on the Friday filed their written opening saying, we think this should happen. The judge emailed them to say, okay, but what's the harm to the child? By Monday morning, they withdrew the case and had to accept that that was the right decision. Sadly, that was too late. The judge was incredibly scathing about their conduct and made a heavy costs order against them. Bianca might know what it was, but I can't remember the exact figure. So one has to be alive to these issues, but for children, there is this huge debate around should children access treatment, should they not access treatment. It is often case specific. What a child needs is often dependent on the case and depending on the knowledge that they hold and their ability to make decisions. As we can see from these cases, 3 examples of how things can change. Final part then of the seminar. How am I doing on time, Rahana? Close. Okay. Final part. How then, now that you have this knowledge, now that you know what being trans means, the vulnerabilities of this particular group, and how they can be discriminated in law and the protections now afforded, which are relatively recent, what does that translate then into for practitioners as to what you should be doing? Well, we have all heard, I hope, the Equal Treatment Bench book. It's what the judges get. It was recently revised in April 2023. I couldn't find a photo of the revised April 2023, so that one says February 2021. And it has a whole section on trans people, chapter 12. And it gives the bench guidance on how these people should be treated. I would encourage all of you to look at this. I would encourage you all to follow this guidance, because if the person in charge of the courtroom is doing this and has to be considering this, so should you. It is used daily by the judiciary. It is referred to in their training courses and commended by the appellate courts, and it is admired around the world. Just to let you know, this book is probably still considered the most recent and updated version in the world. For instance, in Australia, I think their last update was in 2016 or 2018. So they are somewhat lagging behind us in terms of updates and keeping up to date with diversity and inclusion issues. The book isn't law. Of course it isn't law, but judges are expected to take the guidance into account. So how does that translate into what they do? Do they actually follow it? Well, let's look at the case of Gender Identity from 2020. This was a landmark immigration case. And for the first time ever, a non-binary person could have their identity form the basis of an asylum claim. This was a person from El Salvador, and they had presented as a homosexual man in El Salvador, had been beaten up in El Salvador on one occasion by the police in what was a pretty horrific act, kicked, etc., left in the street after a 5-minute assault. The Home Office refused their claim for asylum, and the matter went all the way up, and when it got to the very top, the matter had to be looked at in a lot more detail, because what had happened is between the time that the individual had lived in moved from El Salvador and lived in the UK to the point of the claim being considered, they had done a lot in the LGBTQ plus community. They had grown in confidence, and they had figured out that in fact they weren't a homosexual man, and they would prefer to be referred to as they. And they were gender fluid, and they had grown their hair out, and it was blonde. And ultimately, therefore, if they went back to El Salvador, they would be viewed as a transgender woman. And there was evidence before the court that transgender women, surprise, surprise, are at risk of severe persecution, death, assaults if they went back to El Salvador. So the judge decided that this non-binary gender identity had now, for the first time really ever, left the person in a position where it could be part of the claim and meant that they would be vulnerable if they went back. They would have to face persecution. But what was interesting about it is the judge looked at the Equal Treatment Bench book when forming the judgment, and in the actual judgment, quotes it. The appellant identifies as non-binary. Having had regard to Chapter 12 of the Equal Treatment Bench book, I began the hearing by asking the appellant what form of address they would like to be used. The appellant requested that I use the gender pronoun MX. I have amended the file accordingly, and I've used gender-neutral terms throughout my decision. This is the appellate court. Sadly, the lower court was not as kind. In procedural terms, the failure to make a positive finding on the appellant's identity meant that they were, throughout the first-tier tribunal decision, referred to as he. As the Equal Treatment Bench Book notes, it is important to respect a person's gender identity by using appropriate terms of address. Everyone is entitled to respect for their gender identity, private life, and personal dignity. It should be possible to recognise a person's gender identity and their present name for nearly all court and tribunal purposes, regardless of whether they have obtained a gender recognition certificate. There was some, therefore, slap on the wrist for the lower court for having not respected this person's gender identity and referring to them appropriately. But of course, the judgment also recognises that there is always a balancing act to be done. So it says, there will no doubt be cases where there might be justification for not following this guidance. A case where, for instance, a claim to be transgender has been expressly rejected as false. Decision makers should, however, where possible, apply the guidance in the book and use gender terminology which respects the chosen identity of claimants. I have to highlight that, and I do highlight that to you because it's very important. Everything I've spoken about the vulnerabilities of trans people is very relevant. And where possible, we should try to respect their identity. But there will be instances where there could be a clash of rights, a clash of interests, and we have to look at the situation again. I will turn to that, but let's start from this. So, we know now, Equal Treatment Bench Book guidance for the judges, we know now judges actually use it and put it in judgments and tell you, use it, that's the way it should be done. So what does the book say? As I said, it's important to respect a person's identity by using appropriate terms of address, names, and pronouns. Everyone is entitled to respect for the gender identity, private life, and personal dignity. It is inappropriate to inquire about someone's medical history, including their anatomical status, unless it is legally relevant to the case. If it becomes relevant, the issue should be handled with utmost sensitivity and respect. Private hearing might be directed. Don't ever ask a trans person what's between their legs. It has nothing to do with you, is the honest answer to that question. And the Equal Treatment Bench Book makes it clear that that has nothing to do with how you should address that person and how you should respect them in a courtroom environment. Fundamental principles of equality and acceptance of diversity demand that no prejudice or difference in treatment is accorded. This can include things like how they dress. We all know that you can't dress in an offensive way in a court setting, but that applies to people who are trans and people who are not trans. If a trans person chooses to identify, for instance, a trans woman wears women's clothes, that is not offensive. And they should be and will be permitted to wear the clothes that they feel most comfortable with and express themselves in accordance to how they feel appropriate. It should be possible to respect the person's gender identity and their present name, so the name for nearly all court hearings. What does it tell us? It tells us, and I will encourage you, if you can, to read chapter 12, but I'll give you an overview of it. They go into a lot of detail about how real transphobia is and how hard it is for trans people. They flag that for everyone to consider when you will work with trans people. They tell you that there are risks to trans people if being outed, for the reasons I've already discussed with you, cultural, etc. And that should not be ignored when it comes to how we conduct ourselves. They tell you that if trans people are not respected properly, they won't want to use the court system. They will feel that the court system is not a place for them. And we, of course, know in a democratic society, everyone should be encouraged to use and have access to justice. They tell us about the effect on trans people of misgendering and getting their pronoun wrong, the emotional damage that I have discussed with you. And they tell us about the unwillingness of them to use the courts. What it tells us to do, it tells us that when it comes to issues of names, we can identify at an early hearing how the person would be preferred to be referred to, even if it isn't their legal name, and we can record that on the order. We can then make sure it's used thereafter. It tells us don't slave name or dead name people on orders. I know in family law in particular, and as I say, I'm a family practitioner, so we draft the orders. And so I would encourage any family practitioners and anyone else who has this particular pattern of working in their practice area to amend that order when it comes around, because that is a matter of record that stays on someone's record for life. If you know that this person prefers to be known by a different name, correct it for them. Remember that pronouns, again, can be recorded on the order. Remember that medical history is very unlikely to be relevant. I had a case with a mother and a trans mother, so two parents, And the mother was insisting that my client couldn't have contact because the children shouldn't be subjected to seeing them transition, shouldn't be subjected to seeing their face change and their body change and seeing potential needles being left out. It's not that different from having diabetes when it comes to taking medication, is it? And in terms of someone changing, people change. That's life, isn't it? We don't all look the same. If we're going to start removing people's children because of the way they change their looks, then no one with children should have plastic surgery, should they? So, of course, those are real issues, and you will come across that in court. People raise those arguments. You have to be willing to go to the Equal Treatment Benchmark and say, nope, that's wrong, and these are the reasons why. Medical history, very, very, very unlikely to be relevant. There might be the odd case, and if it is relevant, you have to explain why, and you have to make sure you deal with it sensitively. Know your terminology. Well, we all know now because I've spent a lot of time going through it with you. But now you will know if those words come out, you're not going to sit there going, I don't know what this means. You should now know what the terminology will be. Remember, everyone is entitled to dress in the clothing they feel comfortable in, as long as it doesn't cause offense. And remember that misgendering and disrespecting people can be used as a tactic against trans people. For instance, your witnesses being misgendered whilst they're telling a story during cross-examination and the debilitating effect that might have on them if trying to give evidence. What do you do then as practitioners? Well, my advice to you is don't sit idly by. Flag the book to them. A lot of judges are aware of this. In fact, all of them should be aware of it, but not everyone is. I know of judges who make these mistakes. And my general experience is if you file a position statement telling them, this is what the book says, this is what we should do, and this is what should be recorded in the order, they will bite your hand off in gratitude for having flagged this to them. So be willing to put your head above the parapet and flag this. It will make a big difference for the people who need it. And I put a quote there that we have to consider. Given the lived experiences of trans people, there are issues around their self-esteem, their ability to work with others in a constructive way if they feel that they are facing some form of discrimination, their ability to challenge others, including even lawyers, court staff, or judges, and their ability to speak up and properly engage with difficult issues. A lifetime of being put down can seriously impact on a person's ability in what is a scary and complex arena, court proceedings. Remember that. When they are being misgendered, they are not going to necessarily stand up to correct the room. When they are being referred to by the wrong pronoun or name, or when they know that someone is doing it on purpose, they're not going to be able to speak up. As the advocates in the room, the people who take their jobs very seriously, and we all do this for the right reasons, I don't doubt that, be the one to speak up. Look out for direct and indirect discrimination because it's real. And as I said to you earlier, and I'll repeat again, these issues face us even in 2023. The Women and Equality Select Committee report in 2016 specifically talked about this. Whilst Britain has been among the countries that have gone furthest in recognising LGBT rights, our society is still failing this test in respect of trans people. And that's where we're at. That's sadly where we're at. Consider the following in your cases. Does a particular witness or client or individual meet the criteria under the vulnerable witness provisions? They might. We know that there are always vulnerable provisions in every area of practice. In family law, I know of ours, and there are always those. Does your client, does the witness, does the individual require some form of protection? If so, what special measures can be put in place or reasonable adjustments, like recording on the order their preferred pronouns and names? Should the language be amended? Will they require more of your time in conferences, pre-hearing discussions, the hearing themselves? You might have to stand up to a judge and say, Your Honour, I'm very sorry, but my client has been misgendered for the last hour. Can we have 10 minutes so I can check on my client to make sure that their well-being is being met right now? And I know that that's scary. I know that judges can be very difficult. Believe me, I know. And I also know we don't always put our hands up when we're sat in that moment because of how awful they can be. But I think we have to try. We won't get it right every time, but we have to be willing to try. Will these measures provide your client, your witnesses, the people in court with the courtesy and respect they need to make sure that they feel validated? And remember as well that intersectionality issues can come into play. I spoke to you about public and private hearings. There is a bit in the Equal Treatment Benchmark which quite rightly flags, and I've put it there, where appropriate in the interests of the administration of justice, the court may consider reporting restrictions under Section 4 of the Contempt of Court Act 1981. So if you're ever in a hearing and you think, I need to make sure that my client's protected, there are reporting restrictions, there is law that allows you to raise this issue. There is law that allows you to go, hang on a minute, we might need to just stop here and think about privacy. So be alive to that. I will raise, because I'm a family practitioner, some issues specific to children that I am concerned about. I am concerned that for children who might be trans, sometimes we don't go far enough. For instance, in cases, we might have a child who is trans but doesn't wish for a parent, a cousin, a sister, a brother to know that they're trans. If you represent them, or if they are your witness, be alive to that. Be alive to any restrictions that might need to be raised with the judge in advance to make sure that they are protected and safeguarded. Because for children, this is much harder to bear. It's hard to bear as an adult. For children, it's pretty bad. Remember the psychological distress that they can go through. Remember the high rates of suicide if we don't get it right. Remember that, and this is the bit I wanted to point out, things staying on the record that are wrong can be lifetime mistakes for people. In family law, and if you do care, we know that we have something called a child permanence report. And the reality is, if you have a pretty awful case, you sort of focus on the best material you can, and we say you're scraping the barrel. I suspect it applies everywhere. Not many people, or not everyone, reads the CPR because they think, well, that's just set down. If a child's going to be adopted, I mean, we should, but I know people who don't read the CPR in the trans cases because they might misgender someone in the family. The CPR is a document that follows a child throughout their life. So what you might have is a child who later life decides, I was adopted, I want to reach back to my family, I want to stay in touch and find out who they are. If the CPR misgenders their sibling and calls their sibling a brother throughout, they probably won't find their sibling because there is no evidence out there anymore of their brother being a brother. Or their brother might have transitioned and become a sister. And it's a very easy mistake to correct. In some cases where you have a hopeless case and you have nothing you can give your client, that might be the one thing you can give, is to correct that mistake. Because in 20 years, 30 years' time, correction of that mistake may lead to family ties being united, may lead to people knowing who they are bonded to. So the last thing I want to talk to you about is what we talked about in M&M, which is the issue of where rights and interests can clash. I've spoken to you a lot about respect for trans people, and that is absolutely right. But we also have to be conscious that there may be cases where all the good practice that we've discussed may need to be compromised to achieve other goals. I think one of the big things that have been flagged many, many times recently is the issue of rape victims. What happens if someone who has suffered a horrific rape has to tell their story? Do we reprimand them for misgendering in the middle of their evidence? Is that taking it too far? Will that interrupt how they can give evidence? Well, the Equal Treatment Bench Book gives us guidance on how to deal with those situations. And what it says is there are some situations where revealing someone's trans identity is unavoidable. A person's gender at birth or the transgender history should not be disclosed unless it is necessary and relevant to the particular legal proceedings. Remember, it's a protected characteristic, so you still have to satisfy the necessary and proportionate test, as we always have to do with competing interests. It is unusual for a person's identity to be an issue in a case, or for their old name to be an essential legal requirement unless there's a dispute. Of course, we have to be conscious of that because we might breach Article 8 if we get it wrong. But there may be situations where the rights of a witness to refer to a trans person by pronouns, matching their gender assigned in birth, or otherwise revealing their trans status clashes with the rights of the trans person to privacy. And what the book does is it gives you factors to consider. If you are representing someone where that may need to be a real issue, refer to the book. There is a criteria here to consider, and you can raise it with the judge early on to say, this might arise or this will be relevant in the case. We feel that we might have to compromise on this issue for this reason, and the criteria is there. Whether the trans person's identity is already a matter of public, whether they have a gender recognition certificate. So Section 22 talks about making sure that people have, it's a criminal offence if people's identity aren't respected if they don't have a gender recognition, if they do have a gender recognition certificate. But even then it says there might be reasons why you might need to compromise on that. The impact on the individual, of the risk to them if their identity is revealed, the impact on them if their identity is revealed, the effectiveness on the willingness of the trans people to use the court if they perceive a risk, and why the witness is unwilling and unable to give evidence in a way which maintains the person's identity. As I say, a rape victim might find talking about having been raped by someone who presented as male at the time has to be the way they give the evidence because that's how they recall it. And interrupting the flow of that might undermine the way the evidence comes out. And of course, we want to get the best evidence about issues like that. But there is guidance here that makes sure that when those issues might arise, we manage them sensitively. We raise them early, we look at the guidance, we apply the criteria, and we say to the judge, can we have a determination on this issue now, so that when the trial comes, there's less of an issue around that. There will be occasions when, after these and other relevant factors have been considered, the interests of justice require that a witness or party may refer to the trans person using their former pronouns or names. So it allows you the wiggle room to manage competing interests. And that is where I'm going to finish today. So what we have considered today, let's make sure we cover it. Consideration of the history of trans rights, where we're at, relevant guidance from the Equal Treatment Bench Book, the wider considerations that you need to be aware of when working with trans people, and the competing interests that come into play, and the risks to trans people and others if good practice is not adhered to. Thank you for listening to me. Turn to Rahana now to take any questions that anyone might have.
Thank you so much for that, Reagan. I think I speak for almost everybody in this room. That was absolutely fantastic. I've learned a great deal. As an immigration practitioner of many years, I've learned so much in that small talk, so thank you. We have a couple of questions online, but before I turn to the online questions, I wanted to see if there's anyone who had any questions in the room. If you do so, please raise your hand and a microphone will come to you.
Thank you. Naomi Cunningham, I'm Chair of Sex Matters and a member of Chambers at Outer Temple. You said, Reagan, there is nothing a trans person has to do to have the right to ask you to use their pronouns. And strictly speaking, that's correct, of course, because anyone can ask anything of anyone. They may not get it. So I'd just like to clarify whether by that you mean that you're saying that there's a legal right to have people comply with that request. And if you do, what you say the basis is for that legal right.
So we know that there's been a judgment of force data that specifically says that those who take the view that birth sex is more important, trumps gender identity, is a protected characteristic, they have the right to that view. What I would say is we're not here to discuss our personal views on things. What I'm keen to do is make sure that you as professionals fulfilling your role don't drop yourselves in it. And fundamentally, whilst people have that right to refuse, the case law also says that you might find that you end up discriminating if you conduct yourself in a manner that crosses the line. And so that for me is the concern. When I created this seminar, it was to make sure you all understand as practitioners, regardless of what your personal views may be, what would be considered good practice in your professional capacities, what the judges will expect of you, what people on the ground will expect of you. I accept entirely there is nothing stopping you doing otherwise. But if you do, you may find that you open yourself to a discrimination claim. And that's case specific. I can't tell you more than that, I'm afraid.
Thank you. Any other questions in the room? Should I turn to an online question? I'll turn to an online question now. So the first one is, if following the guidance of asking the court or tribunal and parties, etc., to use someone's preferred name, what is recommended about how the oath and affirmation is taken if they are giving a witness evidence? I don't think it will change.
I don't think it will change. That's why I'm struggling to know what the answer to that question would be, because the oath isn't pronoun specific or...
No, you just state your...
I do solemnly, yes.
I do solemnly, so you state your name. But I think then the material part is what happens if your legal name is different from your identifying name. Sorry, I used the wrong terminology already.
Oh, I see. So when they give their name as part of the start of giving evidence, they give their name, don't they? Well, I would think that's a conversation to be had on a case-by-case basis, because I anticipate most trans people will be happy to, and I say most, will be happy to say, this is my legal name, I would prefer to be known as this, as part of the opening and giving evidence. And then the issue is resolved, isn't it?
Can I give the example? So you mentioned earlier you had a friend who identified, I can't remember the name that you gave, but your friend who identified his ex-name, but had not legally changed her name, because that's how she had to re-enter her home. She had to relate with her family. In her scenario, she has an adopted female name in the UK. So again, if it was in that scenario where she was giving evidence under oath, she would have to use her legal name,
Yes.
not her adopted name.
Well, I mean, she can say, can't
Would
she,
she?
that
No.
this is my name, but I prefer to be known in this way, and that can just be the opening, and then all of the questions that would follow would presumably then use the preferred
Her
name.
name.
I think it's case specific. One of the things I'm conscious of is I can see some judges saying exactly that and going, it doesn't matter, I will go with that name. But there might be some judges who say, no, at least on the oath, because you can end up being held in contempt of court, I would prefer you to use the legal name. I think it's case specific, and I think you should speak to your client about what they would prefer. And again, it's one of those almost ground rule scenario where you may want to raise it with the judge beforehand to say to them, this is the approach my client would prefer. This is what we should say should happen. Where do you sit on that? And deal with it that way.
Yes.
Thank you very much. It was very enlightening, your presentation. I really appreciate your time. I think on the topic, just one comment. I think it's a matter of decency to accept that if someone asks you to address you in one way or another, one does that. I mean, I don't think there's a need for a legal rule to require that. But parking that point, I instructed a KC in a couple of cases that we had in the High Court here, and the judge who sat in the panel, regardless of our KC, painfully trying to explain the importance of using the term transgender, throughout the whole hearing keep insisting in using the word transsexual. And this was a hearing that happened in April this year. I think we all heard Michael Kirby not long ago also making a very important accusation to our top court in cases that came from the Caribbean in terms of equality of LGBTI people. So I guess my question to you, going on the broader topic of LGBT, but not also in the use of terminology as you explained today, what can we do with the judiciary? Are they being trained? Are they actually, what's going on?
Well, the judiciary go through extensive training when they're appointed. Thank you, that's a good question. The judiciary go through very extensive training, and part and parcel of that training is the Equal Treatment Bench Book. It are issues of inclusivity and diversity that they have to respect. So you will find, in my experience, judges who either have recently appointed or are the ones who hold sort of more prominent positions tend to have had this training refreshed or much more on it. There are judges who are not there, sadly, and who continue to not follow the guidance. And the question is, what happens? What do you do when a judge chooses to behave in that way? I would think, I've thought about this, and I think the best you can do is a complaint, because they are not following the guidance that is set down for them to follow. I don't think it's an appeal point unless, for instance, you can frame it around, there were findings made against my client, but one had to consider that my client was under anxiety and stress and might have felt bullied whilst giving evidence. That when the judges formed certain impressions of my client, those matters weren't properly considered. So there's an appeal point if you want to frame it like that, but I think the proper remedy has to be complaint about the judiciary. And I don't know about anyone else who is at the bar, and I'm sorry if there's any judges listening. I think I am really getting to the point where if I'm going to complain, I'm just going to complain. And I would encourage any of you to get to that point as well, because things won't change unless we raise our hands up and say they must.
I'll take an online question, then we'll move to the person at the back. No, not at all. So the next online question is, can you help us with the way to draft an order? And as any practitioner or barrister knows, that's the most painful part of anything, is drafting that order. Should it be XX legal name, hereafter YY preferred name, as an example? So how would you kind of structure an order?
The way I've done it whenever I've had a case is, so we do family law, and at the very top of the order you have the child's name or the respondent's name, and I always include right there and then. So child's name, I don't know, Toby Maguire, and then in brackets I write preferred name, and then the name, close brackets. Then the very first order I will reiterate it and say, upon the court and all advocates and parties noting that the first respondent, the second respondent would prefer to be known as this name, and everyone agrees and the court endorses that moving forward, all orders and legal documents will refer to the person as this name, and leave it at that. And then really, if anyone else breaches it, it's set down. It doesn't have to be as complex as you would think. It's just standard wording, in the sense of common sense wording of how you would express it.
Most orders are common sense, but they
They
skip
did
your
ours,
brain
yes.
the second you're asked to do one. You're like, oh,
Yes.
what's this?
Yes.
Let's turn to the individual at the back.
It refers back to the last point made in the room. My name is Stephen. I'm a serving circuit judge, and I train at the Judicial College as well. All judges who are undertaking courses with the college over the next 2 years course, but I know over the next 2 years, in the next 2 year cycle, all judges are being trained specifically on these points.
Thank you, that's helpful. Do you have more online?
We've got one more online, and then we'll turn to, first of all, this lady, and then we'll come back to you. Thank you. So would be important to not use the term, would it be important to not use the term AKA when referring to legal chosen names on documents?
I would
So
just
instead
say
of saying
the
preferred name rather than
I
AKA.
would say preferred name, but that's more stylistic. I can imagine someone feeling as though you've trivialized it by saying AKA. So I would simply say their preferred name is, to be on the safe side.
Thank you.
I was just saying, AKA is also known as.
Yes.
If somebody's identity is X, they're not also.
There's also
known as,
they are.
just X. So
Yeah.
it is preferred. Well,
No, it's a very good
I'm
point,
not
Karen. Thank you.
on this, but I think it's just stating the obvious, and sometimes just mix the general common sense approach to something.
Yes, I agree.
I think with AKA it also tends to be seen as like an A list that's used in a particular context. So it has that sort of semi-negative kind of connotations to some
Absolutely.
degree.
Yeah.
So if you're being more sensitive, perhaps preferred would be better. If we can hand the mic to the lady with the black jacket.
Hello. Thank you so much for your time. It was a really, really, really good talk. Thank you. From a slightly different perspective, so I'm an aspiring barrister working in a law firm at the moment that regularly instructs barristers. And I'm very aware of my privilege, and I'm very aware that people from different demographics won't necessarily want to talk about it. You've been very kind of vulnerable today, and I'm very grateful that you're willing to come and talk about these issues from a certain position. But when you have a case with any issues, and it doesn't actually have to be LGBT, it can be from different issues. Certain barristers will have different perspectives on that, and I'm just so conscious. So, for example, if there was a case with a trans issue, instructing a trans barrister would potentially have a better perspective on that for that client, and might be the best person to represent that client. But I also don't want to assume and impart on that barrister, because they may not be comfortable necessarily doing lots of those cases, because that might just be something that is part of their identity, but actually they don't want to spend all day every day doing those cases. Do you know what I mean? It doesn't necessarily translate. I just wondered what your perspective was on that, and how to address that, as whether you do instruct those barristers or whether you speak to them first, or whatever you would suggest.
Trans issues are an interesting one, because there are lots of trans people I know who would rather just transition and forget it and move on with their lives. And I don't think they would necessarily, if they were barristers, want to be approached on those issues. On the other hand, there are people like me who try to help in this arena and work on these cases, but there are people like me who people who are better than me, like Dr. Jackson, who has a lot more experience on trans issues. So I think what you should focus on is finding the person who has the experience in that area. If a trans person wants to work on trans cases, you'll know about it, because we speak up about it. Yeah. So when you Google that, it will become very obvious who are the people who have expertise in this, who deal with this often, and who can assist you, rather than going on the fact that they're trans.
Thank you. Again, yes.
Thank you. You talked earlier on in your talk about privacy and the importance of not outing a trans person as trans. And I think I understood you to say that your clients didn't necessarily know that you were. Do you think there are any contexts in which a woman receiving, do you think there are any contexts in which a woman receiving professional services has an entitlement to know the biological sex of the person she's dealing with, even if they don't want her to know?
Do you mean as a barrister, do I have a duty
Well-
to tell people I'm trans, clients I
Well, I'm not
represent?
asking you that specifically. I'm asking you if you think that there are any professional contexts, not as a barrister, but for example, a gynecologist or
Well,
a GP.
I understand, yes, but again, I have to come back to what I'm trying to do today is to assist barristers in their professional capacity. There's a big debate about a lot of these issues, and I'm not suitably qualified to advise gynecologists
Okay, well,
on what they should do.
I was wanting to
I can
make
talk
it.
about as barristers what you should do, and I think that those are tricky questions.
Yeah.
I wouldn't, but that's because I know that I am capable of advising my clients and assisting them the way other barristers are. We've all had the same training to deal with these issues. I don't think my trans identity affects my ability to do my role, but I couldn't assist with gynecologists and other professionals.
Okay, well, I was trying to take it a little away from the legal context in order to make it less personal to you.
Yes.
But putting the question specifically in your context, I think you're a family practitioner. So people talk to you about very intimate things sometimes.
Yes.
Do you think that women who, before they talk to you about very intimate details of their lives, have any right to know
I think this is...
what your biological sex is, or do you think that's none of their business?
Sorry, I'm going to pause it. I think that this particular question kind of goes beyond the scope of specifically what this lecture is looking to deal with, which is namely to provide assistance and guidance to practitioners on how to deal with.
But this is a
clients in
really
the court
important question
system.
for a trans practitioner, isn't it?
I think we can take a debate on that. And I think around this entire issue, we understand that there are many facets to this discussion, and it is to some extent a very heated debate at the moment. And there are multiple avenues in which you can take. But right now, for the purpose of this discussion and this Q&A, we are dealing with something very specific where Reagan has given a talk on how practitioners should be handling a client or potential whoever they come to in
that is specifically what I'm asking about. So I'm not sure I understand why
No,
you say that's not the...
You're asking for speculation as to somebody else. So you're asking for speculation as to somebody else about what information that they may feel they're entitled to and how it may impact them. And that is not a space for this discussion. So I'm going to move on to our next online question. And it is how to pronounce MX.
I knew this one was coming. I knew it. And as I said it to you earlier, I remember thinking, oh, someone asked me at the last seminar, I didn't Google it. Someone said it was MX, and I'm going to go with that, but I don't know is the honest answer. So Google has this phonetic spelling system. Put it in. You know, MEX. There we go. I have no idea. So there you go. I've never everyone else, I remember when Nat West asked me when I changed my bank details, I said, would you like to be known as MX? So they clearly don't know how they were going to refer to me. So thank you, Bianca. That's helpful.
We have one more. I think we'll take that as the very last question.
Thank you. Is it on? Yes. Thank you so much for today. I've learnt quite a bit. My question was, is there a way of knowing a chambers that has adopted a policy that supports trans people? Is it up on their website? Is there, because I know a lot of websites have we support people from marginalized backgrounds, but it's very generic. Is there a way of knowing that specific?
So I can give you an answer to this question that's more my personal view. So I don't wish to offend anyone by giving this answer, but as a person of colour, when I applied, I was like you, very concerned about knowing where people stood on diversity, because just about every website tells you we support equality and diversity. Right? But I think with the benefit of being in the system now and understanding these things, I would say this to you. It will be very obvious getting not only on their website, but Googling their name, who actually believes in this stuff and who doesn't. There are lots of pledges to sign up to. There are programs. There are people who go marching at Pride. There are people who deal with transgender cases that will pop up very quickly on the website. Or a very quick way of doing it, and the way I did it at the time, was actually look to see if they've got any brown people on the website. Because when I applied in 2013, you couldn't find one person of colour on your website in 2013, don't tell me you believe in equality and diversity, just don't. And that's maybe very harsh of me, but speaking very freely, that I think is a big teller. If you've been recruiting for the last 20 years and you've only managed to have white faces on your website, it says a lot about what you're recruiting. So to assist you in your search, and I'm willing to have a more detailed discussion around this with you, that is brutally honest, because I'm always honest with candidates around this. I can have a discussion with you outside, but I hope that assists you in looking.
I think that will take that as our final
Thank
question.
you.
Well, let's thank you again, Reagan, for a fantastic. There are refreshments outside. If you'd like to do some networking afterwards, please. Thank you.